Hello, everybody, and welcome to today's webinar. I'm Evan Farr, and today you're going to be learning how to protect your assets from the expenses of probate and long-term care. For those of you who don't know me, let me tell you a little bit about myself, and you can see this for yourself on the title page here, but I'm one of about 500 certified elder law attorneys in the country. I'm also one of about 100 members of the Council of Advanced Practitioners, which is part of the National Academy of Elder Law Attorneys. I've written 4 best-selling books in the field of elder law, along with hundreds of professional treatises and articles for other lawyers. I'm president of my own financial services company, in addition to the law firm, the Farr law firm. I've been named as a top lawyer by Virginia and DC super lawyers, Washingtonian Magazine, Northern Virginia Magazine, Best Lawyers in America, Martindale-Hubbell, AVO, basically all of the top rating organizations. There's several additional ones that aren't listed here. And I'm the creator of the Living Trust Plus asset protection system, which is used by approximately 60 attorneys around the country that I license it to. And you're going to be learning a lot about that today, along with a lot of other information. And again, thank you for joining us today, and hopefully you'll get a lot out of the information. So diving right in, when you think about suffering from a long-term illness, what are some of your worst fears? Well, if you're like most of my clients, you're worried about winding up in a nursing home and running out of money. Those are the 2 biggest fears. A lot of people have the medical fear of losing their memory, suffering from Alzheimer's or other types of dementia. And a lot of people are worried about all these things and more. Well, for the medical issues, we can't help you on that, although we do publish a lot of good information in our newsletter, which goes out every week, which very often talks about medical innovations and discoveries in the elder care community. But what we really help people with is the running out of money part. And that's a huge part of why you're here today, is to learn how you don't have to run out of money if you do, unfortunately, have to wind up in a nursing home or nursing home level of care. Okay, so you probably didn't know there are going to be quizzes, but there'll be a few here at the beginning. What do you think probate looks like? Do you think it looks like the happy folks here on the left, where the one gentleman saying to the other, here's all you need? Or is it the folks on the right wandering around the maze and the poor guy up top wondering, do I really want to jump into this nightmare-like maze? Well, I'm sure you all got the correct answer on that. And the correct answer is the nightmarish maze. In fact, most often when you hear the word probate, it's part of the term, the nightmare of probate. And that's because probate very often is a complex nightmare. The worst part of probate are the annual accountings. These are documents that have to be filed every year, of course, that an estate is open, which can be any number of years. And these are complex itemizations of all the money coming into an estate and all the money going out of an estate over a 1-year period. And these accountings, as a general rule, have to balance to the penny. People often spend 60 to 80 hours a year preparing these accountings, only to get to the end and find out they don't balance. It could be off by a few pennies or a few dollars or more. And then they have to spend maybe another 100 hours going through all the records for the past year with a fine-tooth comb to figure out where was the mistake or multiple mistakes? You may be looking at, 80 to 100 different bank records as you're going through to do this annual accounting. And if there's one little mistake anywhere, you got to go back and figure it out so they will balance to the penny. These accountings are filed with the court or with an arm of the court called the Commissioner of Accounts. Varies slightly in each state, but bottom line, it's through the probate court in each state, and there's judicial oversight of the process. And there's an open court file, which makes it very easy for people to fight things in probate. For instance, contesting a will, maybe claiming that you were incompetent or being unduly influenced when you signed your will. Probate can also be very expensive. The average fee of a probate estate is 5 to 8% of the estate. That can eat up quite a bit of the assets that would otherwise go to the beneficiaries you've named. Bottom line is all of this is unnecessary. The expenses, the taxes, the red tape, the hassle, the delay, the aggravation of probate, the whole nightmare that we're talking about is all unnecessary because there are easy ways to avoid probate. Before we get into how to avoid probate, let's do another pop quiz. When does probate occur? Is it during your lifetime, after death, or both? Give you a minute to think about that. And I'm guessing a lot of you are thinking to yourselves that the answer is B, after death. And that's not an entirely wrong answer, but the best answer here is C, during your life and after death. Why can probate happen during lifetime? Very simple, and it has to do with incapacity. If you become incapacitated during your lifetime, where you're no longer able to manage your financial and legal affairs, make decisions, make medical decisions, someone is going to wind up going to court asking to have you declared incompetent so that they can be appointed as your guardian and conservator. Some conservator is sometimes just called a financial guardian, but the conservator is then responsible for managing your bills, dealing with all your finances, and guess what they have to file every single year for the rest of your life? The annual accounting, the same one that we just talked about a moment ago, that is part of probate. For somebody who's incompetent and under guardianship and conservatorship, the conservator has to file this horrendous annual accounting that takes 60 to 80 hours or maybe double that a year, and they've got to file that every year for the rest of your life. So lifetime probate is typically much worse than after death probate, because after death probate typically lasts for a couple years, whereas lifetime probate can go on for 10, 20, 30 years, depending the age that the person becomes incompetent or incapacitated. The good news, again, is that it is very easy to avoid lifetime probate. And to do that, you need what is called incapacity planning, what we call in our firm level 1 planning, because it's the very basic type of estate planning that everybody needs to do. We offer 4 levels of planning in our office, and you'll see on the left side of the screen which level we're talking about as we go through the webinar today. Level 1 planning is all about naming people to deal with your financial, legal, and medical affairs when you're not able to, so that they can take over immediately and without having to go to court to have you declared incompetent. The first and most important document that is part of level 1 planning In fact, the most important legal document that every adult should have is the general power of attorney. This is a document that names somebody to manage your legal and financial affairs if you're not able to. So everyone over the age of 18 really should have one of these documents in place in case the unthinkable happens and they're in a car accident and they wind up in a coma, or they have a stroke, or some other tragic event that renders them incapable of handling their own legal and financial affairs. The other thing that's important to understand about a general power of attorney is there is no standard document. There are literally hundreds of different general power of attorney documents out there. And yes, there are lots of simple forms you can find on the internet, and you can get a power of attorney from LegalZoom, which some people call Legal Doom, or Rocket Lawyer, which some people call Rocket Liar, and various other packages. I've even seen people get the most important legal document in their life from Staples or Office Depot. Well, some of these documents are decent, some are even pretty good, and some are really terrible. And the problem is, unless you work with an attorney who knows what they're doing, there's a good chance you're going to get a terrible document that may not hold up or may not do everything you need it to do when the time comes. One of the most critical things that is missing from, I would say, 95% of the power of attorney documents that I review are asset protection powers. And in my world of elder law and Medicaid asset protection, these powers are crucial. Your power of attorney has to have the ability to do Medicaid planning, to make unlimited gifts to your spouse and to your children, to be able to create and fund all types of trusts, including irrevocable trusts. And most power of attorneys, even pretty good ones done by experienced estate planning attorneys, many, if not most of them, lack these asset protection powers. Typically, you're only going to get those if you work with an experienced elder law attorney. The second document that's part of level 1 planning is the Advance Medical Directive. This is the document that names somebody to make medical decisions for you to avoid court-appointed guardianship. In my practice, I've developed and fine-tuned over the years a special type of Advanced Medical Directive called the 4 Needs Advanced Medical Directive. And like the Living Trust Plus, I license this to attorneys all over the country. The first part of the 4 Needs Advanced Medical Directive is the medical power of attorney. So similar to the general power of attorney that names somebody to handle your legal and financial affairs, the medical power of attorney names somebody to make medical decisions for you if you're not able to. The second part is proprietary to my firm and to those to whom I license it, and that's the long-term care directive. This is something I've created over the years because of my in-depth work with elders, and especially elders in nursing homes and assisted living, memory care facilities, where we often encounter the situation where people cannot communicate their own wishes because they've had a stroke, maybe because of dementia, some other illnesses interfere with the ability to speak or communicate. The long-term care directive is a document, and it's actually about 15 pages long out of the 30-page advanced medical directive that we provide to clients. And this lets people get the best possible care if they wind up needing long-term care in the future and they can't communicate. It deals with things like dietary preferences. Do you like uh, to drink coffee in the morning? And if so, how do you take your coffee and how many cups? Or if you like tea, which of the hundreds of types of tea do you like? And all through the day, as far as dietary preferences, foods you like, foods you don't like, certain habits that you have can all be listed in there. Daytime activities is another big one. Imagine you've had a stroke, you're bedridden, you can't really do anything for yourself, and all you can do is watch TV or movies or listen to music or audiobooks. Well, what are your favorite TV shows, types of movies, genres of music, types of books to listen to, different authors, composers? All of these things can be captured in the long-term care directive. Your grooming rituals, such as what type of toothpaste and toothbrush you use, shampoos, what type of conditioners, lotions, etc. All of that information is captured. Sleeping preferences, such as what types of pillows do you like, feather or foam, and how many pillows, and what kind of blankets, light blankets, heavy weighted blankets, triple sheeting, and what are your preferences? So it's all about you getting the best possible care when you are unable to speak for yourself and you're in a long-term care situation. It doesn't guarantee that your wishes will be followed, but nursing homes are required to look at these documents and to follow your wishes as closely as possible. Obviously, if you say something unreasonable, like you want caviar for dinner every night, you're not going to get that unless your family brings it in. But reasonable requests will be accommodated. And if not by the facility, then hopefully, yes, by your family members, if you have family members living nearby. Moving on, the third part of the Advanced Medical Directive is the Near-Death Directive. This is what used to be called a living will, which used to be a standalone document. Now it's part of the Advanced Medical Directive. This makes your wishes known for near-death care. When you have a terminal illness, such as cancer, where you know that there's no chance that you're going to recover, this directs the medical professionals whether you want to be kept alive by artificial means. Do you want to be on a respirator? Do you want CPR? Do you want blood transfusions, dialysis, antibiotics, and so forth? Or do you want to just be allowed to die naturally with pain relief medication? Last part is the post-mortem or after-death directive. This allows you to specify whether you want to be buried or cremated, whether you want to be an organ donor. Do you want to only donate certain organs? Do you want to give priority to certain friends or family members for certain organs? Maybe you have somebody on an organ donor waiting list. This can also be used to write your own obituary and even write list songs you want sung at, or readings you want read at your memorial service. All kinds of things related to what happens after death. All right, moving on. We have another pop quiz. Does a will avoid probate at death? A lot of you are probably thinking yes, or I hope so. And a lot of you also know that the correct answer is no. A will does not avoid probate. In fact, a will is a ticket to probate. The will simply tells the probate court what you want to happen to your assets upon your death. So whether you die with a will or if you die without a will, your estate goes through probate. It's just without a will, the state you live in has laws determining how your assets will be distributed. With a will, you get to determine how your assets are distributed, and you get to specify who will be in charge of that, who is named as your executor or personal representative to carry out the terms of the will under court supervision. Why do people want to avoid probate after death? Well, because of the nightmare, the confusion, the pain, the head scratching, the maze we looked at earlier. And even though the cartoon here is humorous, I can assure you that there's nothing funny about probate. It truly is a complex mess almost all of the time. But the good news is, just like the power of attorney and the advance medical directive avoid lifetime probate, there's an easy way to avoid after death probate, and that's done through a revocable living trust, which is part of what we call level 2 planning. This is for adults in the midst of life, and the whole concept of a revocable living trust is you create the trust. It's an entity that's capable of owning your assets, and you then fund the trust, which means retitling your assets in your name as trustee of your trust. For real estate, we would prepare deeds for your real estate to go into the trust. For financial assets, you will call each institution, tell them you're setting up a trust, ask them to send you the forms to fill out, to change the registration of each account into your name as trustee of your trust. It's that simple. That's how you set up a trust. The retitling or the funding process is a one-time process, and once everything is in the trust, then upon your death, the assets will pass to the beneficiaries you have listed in the trust. Instead of going through your estate, where the will explains to the probate court how you want your assets distributed, the trust simply explains how you want your assets distributed. And those instructions get carried out by your successor trustee, the person who takes over as trustee after your death. People use revocable living trust primarily to avoid probate, also to avoid multi-state probate. That is very important for people who have real estate in more than one state, because real estate by its very nature has to go through probate in the state where it's located. So if you have a vacation home in another state different from where you live, that vacation home is going to have to go through probate in the other state. It's called ancillary probate. And if you own a 1/3 interest in the family homestead that you inherited from your parents in a third state, well, that's gonna have to go through probate in a third state. All of this probate can be avoided with the trust, because we put all the real estate into the trust and multi-state probate is avoided. The trust also provides financial privacy, unlike a will, which is a public record, along with the accounting, the annual accounting we talked about earlier. That's a public record. Inventory of the estate that has to be filed, public record. These are fertile grounds for identity thieves and con artists to go traipsing through your financial affairs, especially if you're a surviving spouse of a decedent, and gives them ammunition for stealing an identity or scamming people out of their money. Trust completely avoids that. doesn't get recorded with the courts and is a completely private document between you and your family members, whoever you name as trustee, successor trustee, and beneficiaries, typically family members. Another pop quiz. Does a revocable trust protect your assets when you wind up in a nursing home? And a lot of you, again, are probably thinking, I hope so, because maybe some of you have done a revocable living trust and maybe your attorney did not answer this question, perhaps because you didn't ask the question. But the answer to this question is an emphatic no. A revocable living trust does not protect your assets while you're alive. This is the main limitation of a revocable living trust. Doesn't mean it's a bad tool. We do hundreds of them every year. And they're a great tool for their purpose, which is to protect your assets from probate. But there's no protection from creditors. There's no protection from the biggest creditor that we all face and the most expensive creditor that we all face, which is the nursing home. No protection from nursing home or any other long-term care expenses. Bottom line is, because you can revoke it and take all the money out, so can your creditors, including the nursing home. Why do you care? Why are we worried about protecting assets from long-term care? Because long-term care is incredibly expensive. There are basically three types of long-term care. There's in-home care, assisted living, and nursing home care. So what's not on this chart is the in-home care, where maybe you're only getting 4 hours a day, 2 days a week, often a starting point, maybe 3 days a week. 4 hours typically being the minimum shift that you can hire. So that can be relatively affordable. It's about $25 an hour here in the DC metro, Northern Virginia area, suburban Maryland. The most agencies run about $25 an hour. You can get people less if you hire them privately through care.com or some website like that. You got to be careful with them, though, because there's payroll issues and insurance issues that you have to take care of because they're not working through an agency, making your life a lot more complicated. So it may seem like you're saving money, but if you're doing it right, you're typically not saving money. In any event, once people need assisted living, which is, let's say, about 8 hours a day of in-home care per day, at that point, the cost of the home care becomes equivalent to the cost of going to an assisted living facility. And assisted living facilities, you can see here, $6,000 to $9,000 a month in this DC metro area. Nursing homes are $10,000 to $14,000 a month. For 24-hour in-home care, that's the most expensive. That can be double almost what nursing homes cost. And by 24-hour home care, I'm not talking about a live-in caregiver, but rather 2 people working 12-hour shifts or 3 people working 8-hour shifts to keep someone in their home because they need literally 24-hour supervision. So these costs, you can see, are just astronomical and catastrophic for most individuals and most families. And that's why people are looking to protect their assets from having to potentially go broke paying these kinds of expenses. Let's look at what I mean when I talk about long-term care. What long-term care is somebody needs long-term care when they need help with their activities of daily living. Activities of daily living are, let's start with the ones on the right because they're self-explanatory: bathing, dressing, eating. The ones on the left need a little bit of explanation. Transferring is getting in and out of a chair or in and out of bed. Continence is the ability to remain continent, or if you have occasional accidents, the ability to properly clean up after yourself. And toileting is the actual ability to physically go to the bathroom, use the toilet, clean up appropriately, and so forth. So typically when somebody needs help with 2 of these 6 activities of daily living, that's when they need the assisted living level of care, and up to 2 of those, and really up to anywhere between 2 and 4 of the activities of daily living. If you need help with, you're at the assisted living level. When you need help with 4 or more of these activities of daily living, then you're typically at the nursing home level of care. And overlaying these physical activities, you also have the cognitive impairments. So a cognitive impairment such as Alzheimer's or any other type of dementia can also cause the need for assisted living or the nursing home level of care. A lot of things cause people to need nursing home care. Looking at just a few of those, stroke is a big one. About 600,000 people a year suffer a stroke in our country. Every 45 seconds, someone in the country has a stroke. Alzheimer's disease is sadly afflicts 1 in 9 people over 65 and 1 in 3 over 85. Parkinson's disease affects about 1 million Americans every year. Of course, the age of onset is typically younger with Parkinson's than with Alzheimer's and other types of dementia. And osteoporosis or osteoarthritis, people having weak bones. Number one, they're at a higher fall risk. And secondly, when they do fall, it's more likely they're going to break a bone. And a broken hip or a broken pelvis, these are a couple of the main causes of people needing nursing home care. We already looked at the expenses. Just a few statistics based on those expenses. 70% of individuals become impoverished within a year of going into a nursing home. That was a study by AARP. Another big study by an insurance company found that 46% of long-term care claimants were under 65 at the time of disability. So this long-term care is not just a problem for the elderly, although it certainly affects the elderly to a much greater degree than the younger folks. And there's long-term care insurance that some people have to help pay the costs of long-term care, but only about 10% of the population has long-term care insurance. And that number is going down over the years as more and more long-term care insurance companies get out of the business. The traditional long-term care insurance market used to have over 100 different companies. Now there are less than, I think, a dozen companies in the country that still offer new policies of long-term care insurance, traditional long-term care insurance. There are many more people these days that are purchasing a different type of long-term care coverage called hybrid long-term care coverage, which typically combines life insurance and sometimes an annuity along with a long-term care benefit. And these policies are much more popular because they have the multiple benefit, and also it's not a use it or lose it premium as you have with traditional long-term care insurance, where if you don't need it, you get nothing back. The premiums you paid for potentially decades are just gone with traditional long-term care insurance. But the good news is for the 90% of folks who don't have long-term care insurance, there are still ways to protect your assets from the expenses of long-term care and probate. And to do that, we need to look at both level 3 planning or level 4 planning, both types of asset protection planning. The goals of level 3 and level 4 planning are similar. The goal is to help people qualify for either Medicaid or a veterans benefit called aid and attendance. And I'll talk more about what these benefits are in a few minutes. It's to help people get these benefits as early as possible while preserving my client's assets in order to preserve my client's dignity and quality of life. Well, what do I mean by that? There are some people who, when they do asset protection of this type, they want to protect an inheritance for their children. But more frequently, the reason that people are doing asset protection is to protect assets so that their life can be better if they wind up in the nursing home. The way that works is that money that is protected either under the control of your healthy spouse, if you're a married couple, or under a trusted child, if you are a single or widowed person, or divorced, that money can be used to make your life better. It can, for instance, the money that's protected in the name of a trusted adult child or children can be used to pay for replacing eyeglasses, dentures, hearing aids, things that Medicaid may not pay for. They can even be used to pay for a private sitter to be with you in the nursing home. Let's say you've had a stroke and, like my prior example, you're immobile. You really can't get out of bed. Well, the private sitter can help you by changing the channel, turning on movies you like, having you listen to audiobooks you like. And if you're able to move at all with help, let's say you can walk with a walker, but you can't get out of bed to use the walker. You can't transfer. Well, that sitter can help you transfer so that you can get to your walker or wheelchair and get to the bathroom every couple hours, perhaps, so that you can use the toilet, because maybe you're still able to do that, even though you can't do it on your own. But having that sitter to help you get to the bathroom every couple hours can avoid you having to sit in dirty diapers for 4 or 6 hours a day, potentially longer, which is unfortunately a very sad reality for many people in nursing homes. So that's the main thing I'm talking about of how protecting assets preserves your dignity and your quality of life. Of course, if you are married, we also want to protect your income and your assets for your spouse who might be healthy and living at home and could be younger and could be healthy for many years to come. And we don't want your spouse to wind up in the poorhouse. Many people want to protect their family home. This is often for a spouse and also often for an adult child. Maybe you have an adult child living with you who was a failure to launch child that never moved out, or a boomerang child who came back after college, or a divorced child who came back to live with you after the divorce, or a sacrificing child who maybe quit their job, maybe sold their own home to move in with you to help take care of you as you were aging and needed some help. Whether it started off with you helping the child or them helping you, it's typically going to turn into them helping you. And most parents don't want to have to lose the home because they wound up in a nursing home. And that is what will happen if you wind up in a nursing home without a spouse. You're just because a child's living there, that's not going to let you keep the home. And then lastly, as I've already said, many people do asset protection in order to protect money for children, sometimes even siblings, not nearly as common, but many people do want to leave an inheritance. And for many people, they have mixed wishes. They want to leave an inheritance if they can, but they're also very concerned about protecting their own quality of life. There's a spectrum of, how much of those two goals people have. Very important to understand that the type of asset protection that I'm talking about today is completely legal, completely ethical. Elder law attorneys do not hide assets. Hide is literally a dirty four-letter word in our business. We legally protect assets or shelter assets. From a legal standpoint and an ethical standpoint, it's just like income tax planning. What does everybody do at tax time? Well, whether you're doing taxes yourself or you're hired an accountant or tax preparation firm, you are trying to maximize your deductions and credits in order to get back the biggest tax refund you can, because nobody wants to pay more income taxes than they have to. That's simply the American way, and getting back the biggest tax refund you can is the American thing to do. Everybody does it, no questions asked. The Medicaid system is funded by our tax dollars, by your tax dollars, by everyone's tax dollars. You work your whole life, you pay income taxes. Medicaid is a federal and state program, combined funding. And the two largest line items as far as spending in the federal budget and in every state's budget are Medicaid and education. So a huge portion of your taxes go to fund Medicaid. If you're smart enough to do legal and financial planning to protect your assets in a way that you can get some of those tax dollars back in the form of Medicaid benefits when you need it, no different from income tax planning. Also no different from estate tax planning, which used to be something very common. Nowadays, for the last 10, 15 years, it's very uncommon because the estate tax exemption is like over $21 million for a married couple, $11.7 million for an individual, actually over 23 million for a married couple, or over 22 million, sorry. In any event, way more than most people have. The estate tax planning is now done by the top 0.2% wealthiest people in the country. But back when I first started practicing law, almost everyone did estate planning because people's estates were over $600,000, many, if not most of my clients. And that used to be the estate tax exemption. And again, nobody gave it a second thought trying to minimize or avoid estate taxes. Ethically, the reason that this type of Medicaid asset protection planning, veterans asset protection planning is also necessary is to overcome our country's discriminatory health insurance system. And here's what I mean by that. The health insurance system in our country doesn't pay for the care that's needed for people who have certain types of illnesses or injuries or diseases, such as someone having a stroke, which is a brain injury, or an aneurysm, brain injury, a diagnosis of Alzheimer's, also a type of brain disease, any type of dementia, all of which are brain diseases. Neurodegenerative diseases, which our medical system has no cure for. These health issues cause a need for long-term care, and our health insurance system turns its back to those people. To give you a quick example of how unfair this is, let's look at two people, two friends. We'll call them John and Joe. John has a cancerous brain tumor. Joe, his friend, has Alzheimer's. Well, what does John have with his brain tumor? He's got a mass in his brain that shouldn't be there. Well, it's cancer. So our health insurance system says, okay, well, we're going to cover everything. We'll pay for chemotherapy, radiation, surgery. If the cancer spreads, we'll pay for all that stuff again. If it comes back, we'll pay for it all again. Health insurance will happily pay millions of dollars to help minimize the impact of brain cancer, maybe get rid of it, most likely just extend someone's life, maybe only extending it for a year or two. But health insurance will still cover all of that. Yeah, there's going to be copays and deductibles. It's not going to be completely free, but most of it, the vast majority, is going to be covered. But we look at his friend Joe with Alzheimer's. What does he have? Well, he's got plaques and tangles in his brain. These are the things that cause Alzheimer's disease. Unfortunately, the care he's going to wind up needing because of the stuff in his brain is long-term care. He's going to eventually need help with all of his activities of daily living, probably wind up in assisted living, and then ultimately in a nursing home. And he's going to have to pay for all this care privately, or his spouse will, or maybe his kids will. In some states, they will even go after children under what's called filial responsibility laws, unless you get Medicaid to cover the cost of the nursing home. So why is this fair? Why should two people who have basically the same problem, they both have stuff in their brain that shouldn't be there, why should one family's illness be covered by health insurance and the other family, they have to go broke to pay for the care that's needed because of Alzheimer's? I submit it's fundamentally unfair. And there are some civilized countries that don't have this discriminatory health insurance system, but it is what it is in our country. And that's why one of the big reasons that this type of asset protection planning is so important. Unfortunately, you don't hear a lot about this type of asset protection planning because it's very poorly understood. And that's because there are only about 500 of us certified elder law attorneys in the entire country. To become certified in elder law through the National Elder Law Foundation, which is certified by or recognized by the American Bar Association as one of the few specialties in the law, you have to go through a 5-year process. This is after passing the bar and practicing for 5 years. You go through this 5-year process, jumping through all kinds of hoops, ultimately being able to sit for a full day elder law exam, which has, the last time I heard, about a 20% pass rate. And again, this is why there's so few of us. This exam has been around since 1988, or well, maybe 1990. The field of elder law came into existence in 98, or in 88 rather. And the exam came around shortly after that. But in a field or in a country with as many elderly as we have, I would hope there would be at least 5,000 of us by this time, but there are still only about 500 of us in the entire country that are certified in elder law, and we are the ones, for the most part, that do this type of incredibly complex Medicaid asset protection and the veterans asset protection. This complexity, here's some more information about that. The United States Supreme Court has actually called the Medicaid laws an aggravated assault on the English language, resistant to attempts to understand it. Kind of funny, actually, but in a morbid way. The Fourth Circuit Court of Appeals, which is one of the circuits right under the Supreme Court, and this was actually a case arising out of a Virginia federal court, it called the Medicaid Act one of the most completely impenetrable texts within human experience and dense reading of the most tortuous kind. These are quotes from court opinions from the highest court in our land and one of the next highest courts in our country, from some of the smartest legal minds in our country, obviously. And I can tell you they're right. This is what Medicaid, one of the huge problems with Medicaid. And in every state, there's 8 bodies of law that govern Medicaid. So it's not like just learning one set of laws. You've got to know where to look for these 8 different sets of laws in every state. Unbelievably complicated, as you can see from these quotes. All right, so let's look at what these 2 benefits that we help people get cover. As far as Medicaid, first of all, what I help people get is long-term care Medicaid, not health insurance Medicaid. That's a completely different program. That's for people with low income. Long-term care Medicaid is not for low-income people, and we're going to look at that income issue in a moment. Long-term care Medicaid pays for nursing home care. It also, in some states, and pays for home care. Specifically in our area, both Virginia and DC offer in-home Medicaid. Maryland does not, unfortunately, not in any real way. And some states and some areas of some states offer the PACE program, which is a daycare program run by hospital systems. The Veterans Aid and Attendance Benefit, that's a cash program for qualified veterans. We'll look at who's qualified in a moment. But what the benefit is, for a single veteran, tax-free income of almost $23,000 a year, over $1,900 a month. Married veteran, over $27,000 a year, tax-free income, $2,266 a month. Surviving spouse of a veteran, almost $15,000 a year, $1,230 a month, all tax-free. How do people get Medicaid? Well, to get long-term care Medicaid, you just need to be eligible. You need to meet the 4 eligibility criteria. The first is medical. You need to be clinically in need of the nursing home level of care, whether that takes place in a nursing home or in your home. As for your income, I just explained that this is long-term care Medicaid is not a low-income program. In fact, I call this type of Medicaid middle-class Medicaid because it truly is for people of all financial means, including people with very limited assets up to middle and even upper middle class people. The income qualification for this program is simply that your income has to be lower than the cost of your care. So if you're in a nursing home and you're paying, say, $12,000 a month, your income simply needs to be lower than $12,000 a month. And guess what? Most people's income is way less than that. So you can have a great income of 5, 6, 7, 8,000 a month. And many people have that in our area, but still get Medicaid. And the general rule is that your income has to go to the nursing home, and Medicaid pays the rest. With married couples, we can shift income in many cases from the nursing home spouse to the healthy spouse, if there is a healthy spouse. The third requirement is the 5-year look back. Medicaid looks back over the 5 years before you applied to see whether you made any disqualifying gifts. These could be gifts to your family, to charities, to your church or synagogue or other religious institution. Any gifts that you made in the past 5 years get totaled up and divided by what's called the penalty divisor in your state or your part of the state, which results in a number, which is a period of months of ineligibility for Medicaid. And the last requirement is your asset level. And this is primarily where we come in, is we help people get their countable assets below the asset limit, which you can see 2,000 for Virginia, 2,500 for Maryland, 4,000 for DC. The general rule around the country is 2,000, but some states are more generous, like Maryland, a little bit more, and DC. The goal is countable assets. And what we do through level 3 planning and level 4 planning, which we're going to explain in more detail in a few minutes, is we protect your assets so that they're still there, but they're not countable for Medicaid. In order to get this Veterans Aid and Attendance benefit, the service requirements are that you have to have been a minimum of 90 days active duty and 1 day during wartime, and no dishonorable discharge. Basically, if somebody was in the military with at least 1 day during the war, they can potentially get this benefit. They have to qualify financially. And to do that, we have to look at your IVAP, which is income for VA purposes. That's your income minus your recurring medical expenses. And the recurring medical expenses is what you're paying for the in-home care or assisted living or nursing home care. You also have to have low net worth to get this benefit. And of course, you have to have a need for medical care, which in the VA language is called aid and attendance, meaning assistance by someone else to help you with at least 2 of your activities of daily living. So now let's drill down and look at level 3 planning. And I know this is probably what most of you were wanting to learn about today. This is the Living Trust Plus. The Living Trust Plus is a special type of irrevocable asset protection trust. And it's called the Living Trust Plus because it protects your assets from probate, like the revocable trust. Plus, it protects your assets from lawsuits, plus Veterans Aid and Attendance if you're a qualified veteran. Plus, it protects your assets from Medicaid and nursing home expenses or home care if you're needing the nursing home level of care. Very, very powerful type of trust used by hundreds of people a year. And that's just in my practice. And again, I license this to approximately 60 attorneys across the country who use it for their clients and have since around 2009 when I started licensing this. So very popular and very powerful. Here's how it works. We start in the top left corner. We have your unprotected assets now, your house, maybe you have more than one house, and your money. We're going to take your real estate, most of your money, maybe not all of it, definitely not your checking account, and we're going to follow the arrows to the right. We're going to move it into the Living Trust Plus. You'll see that's represented there by this rectangle. Once it's inside the trust, there are chains around it, as you can see, and you can see those 3 bullets, which we've already talked about, but again, it's protected immediately from probate plus lawsuits, plus it's protected after 3 years for veterans aid and attendance. That's because that program has a 3-year look back period, similar to Medicaid's 5-year look back. Plus, the money in the house is protected after 5 years for Medicaid. So as for the real estate in the trust, if it's your home or a vacation property that you're using, you'll see this burgundy arrow going from the house to you. And this, as this explains, you're going to have full use of your real estate, just like you do now. You're still going to have to pay the taxes, the insurance, utilities, the mortgage if there is one. You're not going to be able to refinance the mortgage. That's a limitation you have to be aware of. So if you're thinking of refinancing, you want to do that now. Of course, now the rates are lower than they've been in a long time. So if you're at all thinking of refinancing, and you might want to do it, especially if you're thinking of doing this trust, because once it's in the trust, you can't refinance because lenders won't lend money to a trust. So as this explains in the bottom left corner, you can be the trustee of this trust, just like with a revocable trust. And while we're down here at the bottom, I want to point out this green box. This explains what can't go in the trust. So I already mentioned your checking account must stay outside the trust. And your retirement income, assuming you're retired, your Social Security, any pension you may have, all that income continues to come to you each month, goes into your checking account outside of the trust. You still pay your monthly bills the way you do now. None of that changes. And if you have retirement accounts such as IRAs, 401ks, 403bs, any of those accounts also have to stay outside of the trust. Even Roth IRAs cannot be owned by a trust. The I in IRA stands for individual, and under federal law, they must be owned by an individual. The money in an IRA could be cashed out and you pay taxes on it and then put the after-tax amount into the trust. And that may be wise for some people, depending on your tax bracket and where your income falls within the current tax brackets. It often makes sense to maximize the current tax bracket that you're already in, because you know you're never going to pay taxes at a lower bracket. And in fact, the brackets right now are, since 2017, are lower than they have been in our lifetime. And they're scheduled to go up to pre-2017 levels at the beginning of 2026. We don't know, of course, whether Congress might change that in the meantime, but right now is potentially a very good time to cash out income from your retirement account and pay the taxes in order to put it into this trust. The same analysis you might make if you were doing a conversion from a traditional IRA to a Roth IRA. Is it worth paying the taxes now while they're low in order to not pay taxes down the road? That's if you're doing a Roth IRA. With the trust, the question is it worth paying the taxes now at the low rates in order to protect the money in the future from lawsuits and veterans benefits and Medicaid? So now going over to the right side of the trust, this is important to understand that the only way money can come out of this trust is through what I call a backdoor distribution. So if we go back here where the money came in to the trust, I call this the front door. You'll notice that only swings one way. That door goes into the trust. So once you put money into the trust, you can't take money out of the trust. The trustee, whether that's you or a child, cannot use the money in the trust to pay your bills, because that's the equivalent of giving you money. The only way the money can leave this trust is to be distributed out this back door on the right. The trustee of the trust at any time can make distributions of any amount to one of the beneficiaries of the trust, typically your adult children. Hopefully you have at least one trusted adult child who's financially stable and you trust completely to do the right thing, which is, if you need money from the trust, then either you as trustee or your spouse or your child as trustee can make a distribution out the back door to one of your trusted children, who can then give it back to you following these gold arrows, or they can use it for your benefit. That's the mechanics of the trust. As far as the taxes on this trust, there's 3 different versions or flavors of this trust, but this is the main one, and I'm not looking at the other 2 today just because of time constraints. But with this one, the income is taxed to you as the settler of the trust, the creator of the trust. So nothing changes with your income taxes. You're still going to report all the taxes on your 1040, meaning from any investments inside the trust that are spinning off interest or dividends or capital gains. You're going to be taxed on that, and you're going to have to pay the taxes, not the trust, not your children. If you have a house and the house is then in the trust, if you sell the house, you're still going to be entitled to the $250,000 capital gains exclusion upon the sale of the house. That's explained here in the middle of this chart. And if you die owning the home, then your children will receive the home upon your death with a step up in basis. So if it's whatever it's worth at the time of your death is what it would be worth in their hands. So typically when they turn around and sell it shortly after your death, they're not going to have to pay any capital gains taxes. This is completely opposite of if you were to just gift your home to your children. And that's why we almost never recommend, well, really, I do never recommend you simply gift a home to your child, because they're going to take over your tax basis, which is often a low tax basis if it's a home you've been in for many years. And when they sell the home at some future date, they're going to be exposed to potentially very large capital gains taxes. That is avoided with this trust by them inheriting it upon your death. And of course, the trust protects the house from your creditors and your children's creditors. So, whereas if you were to just give away your house, there's no protection from your children's creditors. If they get sued or divorced or go bankrupt or lose a job, your house could be gone. Plus, of course, you're trusting that your kids aren't going to kick you out of the house, which is not likely to happen if you've got a trusted adult child. But it could happen because you never know what might happen. So looking at some of these features again and a couple other features of the Living Trust Plus. Very important, there's no change to your checking account. That stays in your name. Your retirement income, your Social Security, your pensions, your IRA distributions, those still come to you, go to your checking account. You pay your bills just like you do now. You retain the right to live in your home, and you're still responsible for all the home expenses. Again, we have immediate protection from probate, plus lawsuits, plus protection after 3 years for aid and attendance, plus protection after 5 years for Medicaid. And when I say after 3 years, it's 3 years after the assets went into the trust, or 5 years for Medicaid after the assets went into the trust. And if you make additional contributions to the trust after the initial contribution, that starts a new look back period for that chunk of money that you put into the trust. It doesn't change the look back on the initial contribution. Now, what I haven't explained, but is extremely crucial to understand, is that you remain in control of the trust for several reasons. Number one, as we looked at, you can be the trustee of the trust. And as trustee, you decide how the money is invested. You decide if you want to invest assets in a different way, including whether you want to sell any real estate that's in the trust. If you do sell your home or other real estate, the money from the sale goes into the trust because the trust was the owner. So the money would go directly into the trust, into a trust-owned bank account, at which point the trust could purchase a new house if desired, or the trust can make backdoor distributions of money to your children who can give it back, or the trust or the children can pay your rent if you're moving into a rental community after a backdoor distribution. But bottom line, you control the assets in the trust by being the trustee. If you want to be the trustee, if you're still handling your own legal and financial affairs. You can also change the trustee at any time. If you name one of your children and then you have a falling out for whatever reason, or your child becomes ill or marries someone you don't like, you can change the trustee. And most importantly, you can change the beneficiaries of this trust. Even though it's an irrevocable trust, irrevocable does not mean what a lot of people think it means. A lot of people think it means you can't ever change anything, but that's not what it means. Irrevocable just means that you as the creator, whether that's you or you and your spouse, if you're married, cannot unilaterally revoke the trust. Upon your death, it becomes irrevocable. Even if it was revocable before your death. And at that point, you can provide irrevocable asset protection trust for your children. Again, even with a revocable trust that's revocable while you're alive. With this trust, it's irrevocable from the time you set it up. But again, that just means that you cannot unilaterally revoke it. All these things can be changed, including the beneficiaries. So you decide you want to change the beneficiaries, just like you can with your will or revocable trust. You can change the beneficiaries as long as you're competent to do that. And you have indirect access to principal in the trust through that back door. And you also have indirect access to principal because even though this trust cannot be revoked by you, it can actually be terminated by agreement of all interested parties. The interested parties being you and typically your adult children that you have named as beneficiaries of the trust. So as long as everybody agrees, the trust can be terminated and the money goes back to you. Rarely do we do that, but occasionally that's an avenue that we take advantage of. For instance, if somebody were to do this trust and put a lot of money in it, and then a year later they have a stroke and they need nursing home care, we might terminate the trust by agreement of all the parties, and then do level 4 planning, which we'll talk about later, if we could protect more of the assets under level 4 planning. But to finish up level 3 planning, how much can we protect? Well, we can protect theoretically 100% of your assets if you put everything into the trust. And again, it takes 3 years of being in the trust to protect it in connection with the Veterans Aid and Attendance benefit. It takes 5 years to protect it in connection with Medicaid. Now, I just mentioned an example of what happens if you don't make the 5 years. So someone set up a trust and a year later had a stroke and needs nursing home care. We might, in that case, terminate the trust and give the money back and do level 4 planning if we could protect more assets. But that's not necessarily what we have to do. Many times we will stay the course with level 3 planning and still protect significant amounts of money, even if somebody doesn't make the 5 years. So let me give you an example of how this could work and how this does work for many of my clients. So let me give you a very average scenario of a client of mine. Let's call her Mrs. Jones. Mrs. Jones comes to me. She's a widow with 2 children that she trusts. And she has $800,000 of assets. That's comprised of a brokerage account with $400,000, a house worth $300,000, and an IRA of $100,000. She comes to me. We discuss level 3 planning. She decides she wants to do it. So we create the trust and all the other documents for her. It's about 15 different documents all together, and she'll get these in a big padded binder that has estate planning documents written on the front and down the spine. And let's say Mrs. Jones is a healthy 70-year-old living alone, completely competent, completely healthy. Of course, we fully expect she's not going to need nursing home care in the next 5 years. So we set up the trust. But as luck would have it, or bad luck would have it, 3 years later, Mrs. Jones has a massive stroke. She winds up in the nursing home and she's not going to be able to come home. So what do we do in that case? Are we going to terminate the trust and do level 4? No, we're going to continue the trust. And we're going to protect 75% of our assets. Let me explain how that works. So a couple more facts. Her income is just Social Security, and it's $20,000 a year from Social Security. And the nursing home she's in is $10,000 a month. So that's $120,000 a year. So we can apply her $20,000 annual income to the $120,000 a year bill. And that means that she has an annual shortfall of $100,000 per year. Well, her stroke happened 3 years in to the 5-year look back. And let's assume neither she nor her husband were veterans. If they were, after 3 years, we could now get the veterans benefit to help her out. But again, let's say that's not the case for now. So we have to figure out how to pay for her care for 2 years in order to get past the 5-year look back for Medicaid. How do we do that? The first year, very simple. We're going to use her IRA. She kept her $100,000 IRA out of the trust. So I forgot to mention, when we set up the trust, we moved her house and her brokerage account into the trust. She kept her IRA out of the trust because she was in a very low tax bracket. She's in at $20,000 of income. She's in the 12% tax bracket. And for her to have cashed out her IRA would have jumped her into the 22% and all the way into the 24% tax bracket. So over 10% extra taxes. So she didn't want to do that, rightfully so. So we kept the IRA out of the trust. But now it's there. We have to cover the nursing home for 2 years. So the first thing we use is her IRA. And her IRA of 100,000 plus her income of 20 is enough to pay for the first year of the nursing home. And by the way, she's going to get a medical expense deduction on her income taxes, which is going to offset and probably wipe out the taxes that would otherwise be due from taking all that money out of her IRA in 1 year. So we've now covered her first year of nursing home care. Now what's left is the house and the brokerage account. The house, remember, was worth $300,000. The brokerage account has $400,000 in it. And let's assume nothing is changing over the years, just for simplicity. So how do we now pay for the second year of her nursing home care? Again, very easy. The trustee, which is going to be one or both of her children, let's say it's both her children as co-trustees, they're going to make a backdoor distribution of $100,000 to themselves, and they're going to turn around and use that money over the course of the next year, along with mom's income, to pay the nursing home. So again, that 100 we take that comes out of the trust through the back door to the children or to one of the children, can be is added to her income of 20,000, pays the second year of the nursing home. Now we're past the 5-year look back and we can apply for Medicaid. And what's left in the trust and protected is her house worth 300,000 and her brokerage account, which had 400,000 in it. We spent 100, so now it's got 300,000 in it. So there's 600,000 worth of assets left in the trust out of the 800,000 that she originally started with. That's 6/8 of her assets that have been protected, or 3/4 or 75%. So in her case, it made sense to stay the course in order to protect 75% of her assets. Because for a single person under level 4 planning, the general rule is we're going to protect 40 to 70% of their assets. So we're much better off here by staying the course and protecting 75% of her assets. And we'll talk more about level 4 planning in a few minutes. The Living Trust Plus that we've just talked about is a wonderful planning tool, as I said, used by myself and many dozens of attorneys around the country. But it's not right for everyone. It may not be right for you if you don't have a trusted adult child. It may not be right for you if you have a lot of money in an IRA account and you don't want to cash it out now and pay the taxes. And the other thing to understand about the Living Trust Plus is it's not going to cover the cost of home care, or it's not going to help cover home care costs or assisted living costs unless you're a veteran and it helps after 3 years to get that veterans benefit, but that's pretty limited, not nearly as good as the Medicaid benefit. And of course, not everyone is a veteran. So the bottom line is that the Living Trust Plus is primarily a Medicaid asset protection trust, and Medicaid doesn't cover the lower levels of care in the home or assisted living facility. So because the Living Trust Plus is not right for everyone, but because retirement planning and long-term care planning is for everyone, that's why I also offer financial services. And I've had my own financial planning company for over 10 years. And I'm affiliated with other companies that provide full service financial planning, investment advice, and insurance products when needed. And we offer this to our level 2 clients, especially for long-term care planning, but also general retirement planning to make sure people have enough income in retirement, because level 2 planning doesn't provide any protection in connection with long-term care. We also offer this for level 3 planning clients because level 3 planning, as I just pointed out, only helps those who become very sick and need Medicaid, because unless they're a veteran, the Living Trust Plus is only to protect assets in connection with Medicaid. The specialized type of financial and retirement planning that we do is designed to help people in their retirement years, and especially to help pay for long-term care when that care is needed at home or in an assisted living facility. The goal of retirement planning is to help people reduce exposure to market volatility, ensure sufficient retirement income, often consolidating assets for easier management. We want to help maintain account values while continuing the growth opportunities, of course. And we want to develop strategies to help pay for long-term care, especially, again, the home care or the assisted living, which Medicaid doesn't cover. I'm affiliated with a couple companies, as I mentioned. The main one is called Protection Point Advisors. Through this company, you may elect to receive investment advisory services, which are not offered by my law firm, but through Protection Point. We have a team approach. We do the retirement planning. That's a combination of my efforts along with Protection Point Advisors. We offer the estate planning and the incapacity planning. The long-term care planning is a team approach. The investment management and insurance planning is part of this team approach. Strategic tax planning, legacy planning, all of this is myself and my team at Protection Point Advisors and another an insurance agency that I work through, all working together to create complete asset protection for my clients. All right, so that's level 3 planning and a little bit about the financial side of my practice. Where level 4 planning comes in is for clients who come to me where they are already in need of nursing home care, where somebody is either a spouse is already in the nursing home or about to go in the nursing home, maybe assisted living. And the goal at that point is to get the benefits as quickly as possible. So this is also called crisis planning, because it's typically done at the time of crisis, where people are staring down bills of $10,000 to $14,000 a month in the nursing home, or maybe $6,000 to $9,000 in assisted living. And the goal here is to protect as much of the assets as possible, as quickly as possible, and get the benefits in place as soon as possible, not waiting 5 years. So how much can we protect? Well, let me back up. So with level 4 planning, what we do for clients is we put together a comprehensive asset protection plan. This is a written 25 to 35 page document that's going to explain the different asset protection strategies that are possible. In this world of level 4 planning, there are over 24 different asset protection strategies. In any given case, we're going to use typically between 5 and 10 of those strategies. So in your asset protection plan, we're going to explain which of those strategies make sense. Let's say it's 10 strategies that could be used. We're going to explain each of the 10 strategies, how much it protects, how it works. You're going to review it. You're going to have your family members, whoever you want, to review it. Then we're going to have a follow-up meeting with me and one of our 4 Medicaid paralegals, one of whom would be your primary point of contact throughout the process. And we're going to answer all your questions and narrow down the strategies and decide, okay, of these 10 strategies, which ones do we actually want to use? In any given case, we're typically going to use 5 to 7 of those strategies. Once we decide which strategies we're going to use, then it's time to implement those strategies. And for the most part, our team is going to implement each strategy. We're going to take the steps needed to put everything in place. If there are steps you need to take, we're going to guide you every step of the way so that you don't step on a Medicaid landmine and have things blow up in your face. And that's unfortunately a very real risk of Medicaid when you try to do it yourself. And again, that's because it's the complexity of Medicaid being the most complex area of law in our country. It is filled with traps and landmines that can blow up in your face. And that's why we handle the entire process to make sure that doesn't happen. And ultimately, after these strategies are all implemented, we are going to apply for Medicaid or the veterans benefit when that's applicable. We're going to handle the application for both of these benefits. This slide explains that for a married couple that we are getting Medicaid for, we can protect 100% of their assets. And yes, you're reading that correctly, and I'm saying it correctly. And I know this is confusing and astonishing, but it's the truth. And that is, with a married couple, as long as one spouse is still healthy and living at home, the other spouse is in the nursing home, we guarantee we can protect 100% of the assets for the healthy spouse. So it's not going to, unlike the trust that protects the assets for both spouses, if they both wind up in the nursing home, this is protecting the assets in the name of the healthy spouse, getting the nursing home spouse on Medicaid. And this has to do with the fact that the 5-year look back period doesn't work the same for married couples as it does for individuals. And because of that, we have strategies where we can protect everything for a married couple and get the nursing home spouse on Medicaid in 2 to 4 months. That's how long the process takes. For a single person that we're getting Medicaid for, as I mentioned earlier, we can protect 40 to 70% of the assets. That's what we guarantee. Sometimes it's 100%. Depends on the situation and the strategies we're able to use. But in some cases, we can protect all of the assets for a single person. With the veterans benefit, there's no fixed percentages. It's a much more complex analysis of how much we can protect, and it varies tremendously depending on how much assets somebody has. So let me just give you a quick example of level 4 planning for an average middle-class couple. This is Jane and Bill. This was an actual, not the picture, but this was an actual case history from one of my clients from many years ago. Jane was at age 80. She fell, she fractured 3 vertebrae, and then she had a massive stroke on top of that. She wound up in the nursing home just up the street from us for the rest of her life, which was over 5 years in the nursing home. Luckily, her husband came to us right away to do level 4 planning. He was still healthy, living by himself. In the asset protection plan that we did for them, for the husband, we always include a financial summary. In this case, you can see his financial summary listing all of his assets. It's hard to see the bottom total there, but the total of his starting assets was just over $859,000 of assets. Again, pretty typical middle-class Northern Virginia client. In their case, we used 5 different asset protection strategies out of the 24 available, and we protected just over $859,000. We protected 100% of their assets, which is what we're always able to do for married couples. And not only do we protect all the assets for the husband, but we reduced the monthly nursing home cost. This is out of the asset protection plan, and this is from quite a while ago. I'm thinking like 10 years ago is when Fairfax Nursing was $9,000 a month. They've been at over $12,000 a month for many years. And during the time she was there, it rose to at least $11,000 a month during her stay. So this was the bill when it came to us. He was paying $9,000 a month initially for her care. And then once we got her approved, this is the notice of action from Medicaid. And it's hard to see, but this was from September 1st, 2010. So yeah, like a little over 10 years ago. But we do this every day, every year. And her notice of action, as you can see here, he only had to pay for her nursing home care, where he was paying $9,000 a month. He only had to pay $252 a month. That was ongoing, which you can see circled here in red. That was for the rest of her life. And she, like I said, she was in that nursing home a little over 5 years, dying in early 2016. So he saved all that money every month. And the reason her patient pay was so low is it's based on her income. Even though they look at all the assets of a married couple, they only look at the income of the spouse who's in the nursing home. So she only had income of, I don't remember exactly, but $500 or $600 a month. And from that, they let her keep $40 a month as what's called the personal needs allowance to pay for things like haircuts and nail trims. And they let her keep enough to pay for her health insurance monthly premium. And what was left was this $252 a month that had to be paid as her cost of care. So you can do the math yourself and figure out the amount of money he saved over 5 years of care, but it was extremely significant. And he, like all of our clients that do this type of planning, was very happy that he hired us, of course. So just a quick recap of what we've talked about today. And by the way, I see some of you have already asked questions. If you do have any questions at any time, just pop into the Q&A section and we'll take those at the end. The level 1 planning that we started with talking about is the incapacity planning to avoid lifetime probate. Level 2 was estate planning, adding the revocable living trust to protect assets from after death probate in addition to lifetime probate. Level 3 planning, the living trust plus, protecting your assets from probate plus lawsuits plus the Veterans Aid and Attendance plus Medicaid. And lastly, what we just looked at, level 4 planning, which is the crisis planning, benefits focused asset protection planning, where we can protect 100% for a married couple or 40 to 70% generally for a single person in connection with Medicaid. Why doesn't everybody do this type of planning? Well, a lot of people make a lot of excuses. The top 5 I'll talk through here. A lot of people think their estate's too small to do planning. They think they don't need to do estate planning. There's a crazy myth that I've heard probably a dozen or more times over the years where people think they don't need to do estate planning unless they have over $1 million. I have no idea where that myth ever got started, but bottom line is there's no estate too small to do planning. People come to us even for level 4 planning, and they may only have $10,000 or $20,000 left, but they want to protect what they've got, and they want us to apply for Medicaid to make sure it's done right. Too many choices is a big excuse. Most people have heard about wills. They've heard a little bit about trusts. They don't know what they should do, so they do nothing. Paralysis analysis, or analysis paralysis, from having too many choices to analyze. And one of the things you've hopefully learned today is that for most people, the right choice in the decision of a will versus a trust is a trust. Most people, a trust is more appropriate. There are some cases where having a trust is not appropriate, particularly in level 4 cases. We don't use trusts for level 4 planning. But the other, anything other than level 4 planning, a trust is usually the best course. And of course, I've given you this Living Trust Plus to think about today. And do you do a revocable trust or the Living Trust Plus? Well, it can be a difficult choice for some people. For some people, it's very clear one way or the other. But regardless, if you come in to meet with me and we offer free consultation, which I'll talk about in a minute, we will help you make that choice. And that's what I, as an elder law attorney and estate planning attorney, help people do every day, is to help you figure out what makes the most sense for you. Ultimately, it's your choice what type of planning to do, if any. But we're never going to pressure you into doing anything. But part of my job is to help you figure out what makes the most sense and to help you make that choice. The Medicare myth. This is a big one. And I don't think I talked about this earlier, but well, I did. When I was talking about the ethics, I explained that health insurance doesn't cover long-term care. Well, Medicare is health insurance. Medicare does not care about long-term care. Medicare only pays for hospital bills and doctor's bills. And where there's some confusion, where a lot of people are rightfully confused, is if somebody has been in a hospital for 3 days, say because of a stroke or a broken hip or some other problem, and they go then from the hospital into a nursing home for short-term rehab, that will be covered by Medicare and your secondary health insurance. But that's only short-term. That's for Medicare covers 20 days in the nursing home for rehab, not for long-term care. And Medicare will cover up to another 80 days partially And then if you've got good supplemental insurance, that will pay some or all of the additional 80 days. Doesn't mean you're going to get the full 100 days of rehab, but you'll get some of that, and sometimes all of it. And Medicare will cover that, but all of that is short-term rehabilitation. Medicare will never pay a penny for long-term care in a nursing home. Quality of care myth. This is another big one. A lot of people think that if they go on Medicaid, they're going to get substandard care. Completely untrue. The quality of care is the same in a given nursing home for people paying privately or for people on Medicaid. Are there differences between nursing homes? Absolutely. There's actually a rating scale done by the federal government from 1 to 5 stars, and there are 1 and 2 star nursing homes, and there's 4 and 5 star nursing homes. And obviously there's a difference in the quality of care between a 2-star and a 5-star nursing home. But it has nothing to do with Medicaid, because almost every nursing home takes Medicaid because they have to. It's a practical matter that people in nursing homes run out of money. And if the nursing home wants to get paid, they need to take Medicaid. And they don't make as much money on Medicaid patients, but they make money. And in fact, most nursing homes make the bulk of their money from Medicaid patients because very few people can afford to pay privately for nursing home care. But the bottom line is federal and state laws prohibit nursing homes from giving poorer quality care to people on Medicaid. Nursing homes cannot discriminate against people on Medicaid and give lesser care. And the reality is the people on the floors delivering the care, the nurses and the certified nursing aides, they don't even know who's on Medicaid and who's not. In most nursing homes, the Medicaid people are mixed in with the private pay. You could have 2 people sharing a room, one's on private pay and one's on Medicaid, with the same caregiver each day, getting the exact same type of care. And that's the reality, is there's no difference in the quality of care based on Medicaid. The biggest excuse that people make is just denial. The folks who say, I'll never go into a nursing home. I've told my son to take me out back and shoot me if I ever have to go in a nursing home. I hear that probably once a month on average. And obviously that's not a good idea, because that's generally considered murder and people go to prison for that, often for a long time. And the good news for you folks is I'm preaching to the choir today, because you folks who are on here are not in denial. You're not hiding your head in the sand, because you took 2 hours out of your day to listen to this webinar and to understand different things that can be done to protect your assets in connection with nursing home care, because you recognize that even though you may not want to, of course, very few people want to go in a nursing home. Unfortunately, it's a reality that it might happen. The statistics are that after age 65, there's a 70% chance of needing long-term care, and 40% of people wind up in a nursing home at the end of their life. The average stay is about 3 years in a nursing home, but again, that's average, and obviously not everyone's average. We have clients that have been in there for 6 months, and we've got clients that have been in there for 10 years or more. So that's how averages work. And you never know how long you may be in a nursing home. Even if it's 1 or 2 years, do you want to spend $150,000 a year or more paying for nursing home care when you don't have to? And for most people, the answer is no. And that's why you need to consider this type of planning. So again, I congratulate you for not making excuses, for listening today, and understanding that there are things that you can do to plan to protect your assets from probate and from long-term care. I encourage you to start the process of creating your own plan. And the next step for that is simply to call our office to take advantage of a free introductory meeting. You'll meet directly with me, and unless you're looking to get in at a specific date and time and I'm not available, in which case we have 3 other attorneys you can talk to. We have, give you an idea of the firm, we have 16 or 17 employees in the firm. So we're a pretty good sized law firm, and we have the manpower to support all your needs. But your introductory meeting will be with me. Most meetings these days are done via Zoom, via a video conference. If you're not tech savvy or don't have a computer, we can do a phone call. It's the Zoom calls are much better and much more productive. Or we can even do it in person. Some people are not computer literate and not good at hearing or listening on the phone because they may have some hearing loss and they want an in-person visit. We are offering those. Of course, I say in person, it's not really face-to-face because we're all wearing masks these days, but we do offer the in-person appointments if that's what you prefer. We do offer an incentive. If you want to schedule your meeting today, you can just mention this webinar and you'll get a $500 gift certificate. And that would be off of whatever level of planning that you wind up doing, assuming you do hire us. And again, there's no obligation. There's no high pressure. We're all about educating people. This webinar is free. The consultations are completely free, no obligation whatsoever. Presumably, you're listening today because you know you need to do something. And do we hope you're going to use us to do that something? Of course. And we're going to help steer you towards what the right thing is for you to do. That's our purpose. We do ask for an intake form to be completed, and that's something when you call in, we have a client service team of 3 or 4 people that answer the phone and can set up your appointment, and they'll give you the intake form link, or they can email it to you to fill out. You can either print it, fill it out, or fill it out electronically. We also have a free newsletter. I would encourage you to sign up for that. When you do sign up, you'll also have a chance to download a free ebook on Medicaid asset protection trusts. You'll also have a chance to purchase two of my hard copy books are available, or not, I shouldn't say purchase, they're available for free on that same site, but you do have to pay shipping and handling. It's a nominal charge. And of course, all of my books are available on Amazon. Well, all but one. One's available only through our office, but the other 4 are available on Amazon if you want to check those out. And with that, thank you all for attending today's webinar, and I'm going to take questions. And if you have questions, feel free to go to the Q&A section and I will try to get to your question. All right, so the first question is from Charlene, is actually a long-term client of mine. She's asking for irrevocable trust under level 3 planning. Can this still work if a person does not have children? Well, it can, but it's much more difficult. So it depends who your beneficiaries are. So as long as your beneficiaries are people that you trust, whether that's a sibling or a niece or nephew or even a close friend, if that is somebody that you completely trust that has your best interest at heart, and you trust them to be the backdoor beneficiary. In other words, if you need access to money in the trust, you trust that if you make a distribution to that person, they will give it back to you if in fact that's what you want. Then yes, this can work even if you don't have children. It's a rare case where we do this for a client that doesn't have trusted adult children, but we've certainly done it, probably half a dozen times in the last 15 years that I've been doing this trust. So yes, it's certainly possible, but just more difficult. All right, the next question. I assume the Living Trust Plus applies to those 65 or older due to Medicaid eligibility requirements. Can the 5-year wait period begin at age 60 or does it start at 65? So great question. So it's not just for people over 65. The people at any age can do it. And if you do it at 60, the 5-year clock starts at 50. We've had clients even in their 40s and 50s do the Living Trust Plus because one spouse was diagnosed with early onset Alzheimer's, for instance. And that's a perfect client for doing this type of trust, or a single person at that age. If you get a diagnosis of any kind of dementia and you're under 65, that's a time to do this trust, the Living Trust Plus. So yeah, it works at any age. It's just that 95% of the time it's done by people who are 65 or older because they're retired. Typically their adult children are older, they're more settled in their lives, they're typically married, you know who their spouses are, you know if you can trust their spouses because spouses can influence your children. So there's a lot of reasons why we typically only recommend the Living Trust Plus for people over 65, but I have done it in many cases for people under age 65. Another question, how much, in connection with Living Trust Plus, how much is a lot in an IRA or a 401k retirement account? So I mentioned, you may not want to do, level 3 may not be right for you if you have a lot of money in an IRA. And really what constitutes a lot depends on the client. So if a client only has $200,000 and it's all in an IRA, that's a lot because it's all their assets. If a client has $1.5 million of assets, but it's a house and a house worth $500,000 and $1 million IRA, that's a lot in the IRA because it's everything but the house. Might you still do the trust? Sure, to protect the house. And might we cash out a big chunk from the IRA and put that in the trust? Absolutely. And we would look at the tax charts to see if that makes sense. All right, next question. How are inheritance tax obligations affected in a revocable and irrevocable trusts where the clients continue to live in the home? Okay, so the question's about inheritance tax, and this is complicated because it's not clear. For most people, they don't understand the difference between estate tax and inheritance tax. So let me talk a little bit about that. So first of all, I did mention earlier that estate tax is, and gift tax, which go together. Gift and estate is unified. And there's a unified credit right now of $11.7 million per person. And that's taxable to the estate or to the giver of the gift, which is either you while you're alive or your estate upon your death. So very few people ever pay gift or estate taxes because very few people have more than $11.7 million or double that for a married couple. The inheritance, backing up, the estate tax is never a tax to the recipient of an estate, and the gift tax is never a tax to the recipient of a gift. It's to the giver. The inheritance tax, on the other hand, which only applies in certain states, that's a tax on the recipient if they live in a state that has inheritance tax. So for instance, Virginia has no inheritance tax. Maryland has a small inheritance tax. But it's very small for most beneficiaries, like a spouse or children. There's pretty much no inheritance tax. For other people, the farther away you get in degree of kin, it's a higher percentage, but it's still a very tiny percentage. So the inheritance tax is, maybe 1 or 2%. It's not like a state tax, which is 40%. So a state tax or inheritance tax rather, is basically not an issue for most people. And if it is, it's a very minimal issue, and it can't be avoided. It's on whatever somebody inherits, whether it's through a revocable or an irrevocable trust. It doesn't matter. All right. Next question. For long-term care Medicaid, you mentioned that it's not for low income. What are the advantages and qualifications as compared to Medicaid? Well, I don't really understand the question. So long-term care Medicaid, people with low income can get it, certainly, but you don't have to have low income to get long-term care Medicaid. If you're asking about regular Medicaid, that's just health insurance that people get through Obamacare or through healthcare.gov. That's for people with low income, and that's welfare. That's a completely different program than long-term care Medicaid. Okay, next question. Both my wife and I have long-term care insurance policy. How will this impact me? Great question. So, excuse me. So the long-term care insurance is wonderful when people have it and they have it in the right amounts and for the right duration. And I recommend, in fact, I sell long-term care insurance, both traditional, though that's few and far between, and those hybrid policies that I talked about, where it combines insurance or life insurance or an annuity with a long-term care benefit. So where long-term care insurance is great, even for people who have the Living Trust Plus, is that the long-term care insurance, most of the policies will cover home care and assisted living. Whereas again, the Living Trust Plus only protects assets in connection with the nursing home level of care. So I think it's very helpful for clients to have both long-term care insurance to cover home care and assisted living, and the Living Trust Plus to cover nursing home care and to allow them to get Medicaid after 5 years, because rarely does long-term care insurance last for more than 5 years. Most policies are 2 or 3 years. And even then, they don't pay the full amount. Okay. Another question, is there a lawyer in or near Springfield, Illinois that you've licensed your Living Trust Plus to? So I don't know offhand, but if you are in another state, and I saw there was another question from someone in another state, and that's great, but I don't practice in other states, so I can't give advice on other states. I can tell you the Living Trust Plus, to my knowledge, works in every state except Minnesota. And if we do have someone in Illinois, they would be listed on the website livingtrustplus.com. That's where we have listed all of our affiliated attorneys. Next question, when disbursements are made through the Living Trust Plus, is it a taxable event for the beneficiary? No, it is a gift to the beneficiary, it is never going to be taxable to the recipient, because again, gifts are never taxable to a recipient. And there is a potential gift tax return that needs to be filed by the client who created the trust. So if the trust makes a gift of more than $15,000 per year to one individual, then the creator of the trust is supposed to file an informational gift tax return that is going to report to the IRS that they made a gift in excess of this annual $15,000 exclusion. So the IRS knows that there's a potential estate tax on that gift. For 99.8% of the population, they're never going to pay taxes on that gift because they're not going to be giving away or dying with more than $11.7 million. So most people don't have to worry about ever paying gift or estate tax, but you might have to file one of these informational gift tax returns. All right, and the last question, unless anybody else wants to jump in there, we have long-term care insurance policy, but the premiums keep increasing and the financial planner lost the policy years ago. Ooh, can you help with different options? So absolutely. Art, we are happy to help with different options. We can look at trying to get a hold of your policy, number one. As long as you know the company it's with, we can contact the company directly to get a copy of the policy, find out what the benefits are, explore, and you're right, your premiums have increased, and that's why most people don't have traditional long-term care insurance, or if they did, they'd let it drop because the premiums went up so much over the years. So we can explore whether it makes sense to keep that, whether it makes sense to reduce your benefits if you still have that option, or whether it makes sense to replace that policy with one of these hybrid policies, or whether it makes sense to not have it at all and to do the Living Trust Plus. So I help with all of those things. All right, have one more question here. Okay. My husband has early onset Alzheimer's. I'm planning to retire early, moving to Virginia. Which level is best? He has a retirement account. We already have wills. Okay, so this is a complex question, very fact specific. So Deborah, you would just need to make an appointment, come in to see me. We'll have to look at the factual specifics of your case. You mentioned your husband has early onset Alzheimer's, but I don't know when that early onset arose. If it just arose, if he's still in the early stages, level 3 planning might make sense. It also depends on your age and whether you have children together or it's a blended family. And, on the other hand, if he's in the middle to late stages of Alzheimer's, level 4 planning might make sense. Or just doing level 1 planning and waiting till level 4 planning. So you just said he's in the middle stages. So I appreciate that. And, it's going to depend on your age and your family situation as to what makes the most sense. It's really not something I can answer without having all the facts. And that's why we have a comprehensive intake form. And that's why we offer the free consultations, is to get at the facts and to see what makes sense and to give my recommendations. So every case is fact specific, and these more than most are very fact specific with dementia, because we have to analyze a lot of different factors. So thank you all for listening. That's all the questions I see. If you have a question that did not get answered, you can feel free to ask it when you come in for your free initial consultation. I hope I'll see you for that. And again, thank you for listening in today to our webinar. I hope you'll let your friends and family know about us as well. We offer these webinars every month. Typically, it's on a Thursday. And again, I encourage you to sign up for our newsletter. And if you're not already on it, encourage your friends and family to sign up so they can get notice of when our next webinars are. Again, thank you all for coming and hope you have a great rest of your day. Take care now.